Welcome back to The Lawyer You Know. Today, we're going to cover the United States Supreme Court. It has been a wonderful time to be watching the Supreme Court. So much is going on and so much significance is happening with the cases that are there. And they got there in many different ways. And one of the things we're going to cover is the procedures. How do things get to the Supreme Court and what happens once those cases get to the Supreme Court? But the two cases we're going to be focusing on as great examples is the Dobbs versus Jackson case, and that's the case that may overturn Roe v. Wade, the abortion case. And the other involves the OSHA case, which is the vaccine mandates for those individuals that have companies over 100 employees. That also covers a second oral argument that is going to be, and it's also joined in the same day, is going to be the oral argument about healthcare workers and the mandates for them to get vaccines. So these are going to be significant decisions that are going to be coming out, and the oral arguments just recently happened. Let's begin with the OSHA case. And this case involves the 100 employees, and they have to be vaccinated or they have to have weekly tests, and the employer doesn't have to pay for the weekly tests. Along with that, and traveling along the same way, is the case involving healthcare workers and whether they have to be vaccinated. Now, OSHA passed this rule, and the rule was, of course, immediately appealed. The lower courts in the appeals, some of them have said, we're going to stay those rules because we want to have it fully briefed and fully argued and give everybody time to argue the case. Some have said that we're going to go forward, we're going to have these rules, and you guys are going to have to comply with this OSHA mandate. The Fifth Circuit Court of Appeals said it was going to stay the OSHA mandate, which means it was going to stop OSHA from enforcing those mandates. Well, the interesting thing happened that right after that, the Sixth Circuit Court of Appeals, another court of appeals, said, no, we're not going to have that stay. We're going to let OSHA go forward with this. Well, then you can see we have a conflict in the courts, and it has to be resolved, but it has to be resolved quickly. So emergency motions, an unusual procedure, and it's known as the shadow docket at the Supreme Court, where emergency motions are heard by the Supreme Court. So there was an emergency motion for the Supreme Court to get involved in this case. And for the first time since 1970, and that was the only time it happened, the Supreme Court granted an emergency motion on two cases at the same time, and both of them having oral argument on the same day. And that is the OSHA case with 100 employees, and that is the case for the healthcare workers and the mandate for their vaccines. So they got an emergency motion, which means everything speeded up, timetables, everything, none of the normal rules apply. And of course, the rules belong to the Supreme Court, so they can change the rules anytime they want. So they had an expedited briefing schedule, which means the written submissions had to be in quickly, oral argument happened quickly, and they gave them extended time for oral argument. Usually oral arguments are only 30 minutes, but they granted them extra time in order for them to present their positions and their views. What happens generally is that when an oral argument happens, before that oral argument occurs, the justices read all of the brief, all the written submissions. They also have law clerks that read those submissions. Those law clerks prepare memorandums of law. Those law clerks prepare questions for the justices to ask. The justices themselves prepare questions. But then they go into the oral argument and they pepper the lawyers with questions. Even though the oral argument means the lawyers are supposed to speak, most of the time justices ask questions, and most of the time is taken up by the lawyers answering the justices' questions. In this particular case of the vaccine mandate, you saw the split, as we would expect. The three liberal justices, Breyer, Kagan, and Sotomayor, those three were concentrating on the facts. And what do I mean by that? There are always two parts to any case. The law, which is the past cases that have come up or the statutes written by Congress, and the facts of the case that are applied to the law. The liberal justices concentrated on the facts. Facts being We have deaths occurring in this country. We have a pandemic occurring in this country. People are getting sick. Our hospitals are overwhelmed. Our healthcare workers are overwhelmed. All the first responders are overwhelmed. We need to do something about it. The facts of the case are horrible. Now, unfortunately, we have some misstatement of the facts during that oral argument. Sotomayor said that there were 100,000 children seriously ill because of COVID. The facts really are there are 4,700. And so she made a bit of a mistake. Something else she said, there are more deaths than ever. Well, that isn't true. There are not more deaths than ever. There are fewer deaths now than there were a year ago. So she really wasn't right on with the facts, but that's what the three liberal justices concentrated on. The conservative justices, which is Justice Roberts and the other six, Roberts being the Chief Justice, concentrated on the law. Does OSHA, or does an executive department of government, have the right to tell employers they have to get vaccines? Do they have the right to tell people and interfere with their health care decisions? Does the statute that established OSHA give them the authority to order health care mandates? The statute doesn't have anything to say in there about ordering health care mandates. It has nothing to say about ordering what kind of decisions about their health individuals who work at a company have to make. And the government, there's nothing in there about saying the government can make those decisions for you. So they concentrated on whether or not the law would allow OSHA to do this particular type of activity. So once we finished with the oral arguments, then what happens? Well, you're going to have to wait because we'll move now to the second case. And this second case is the case of Dobbs. And Dobbs was the case out of Mississippi where the Mississippi legislature said you could not have an abortion after 15 weeks. And that was appealed to a district court, a trial or the lower court. The district court said that that law was unconstitutional because of Roe v. Wade. It was then appealed to the Fifth Circuit Court of Appeals. The Fifth Circuit Court of Appeals said it was unconstitutional because of Roe v. Wade. And these arguments go to viability. So what do I mean by viability? That is when a child is viable in the womb, where that child was in the womb, but if they were out of the womb, the child could live. Right now, science says that's somewhere between 24 and 28 weeks. As science progresses, those dates or time periods kind of change. But it's generally accepted that 24, 28 weeks is about the viability. So when you go to 15 weeks, that means that they did not think about viability when the Mississippi legislature passed that law. They arbitrarily set 15 weeks, which means the child is not going to be viable. And therefore, it violates Roe v. Wade, who spoke about viability. So now we've got, again, this is the normal process. District Court, Fifth Circuit Court of Appeals. So now a writ of certiorari. A writ of certiorari is a document filed with the United States Supreme Court asking them to voluntarily take this case. The Supreme Court does not have to take a case for the appeal. The writ of certiorari is written to convince them to take the case. This is the normal way it happens. Remember, when we were talking about the OSHA case, that was an emergency motion to accept a case. An emergency motion bypasses all the things like the certiorari, all the normal things you would do, and goes directly up to that Supreme Court for them to make an emergency vote. In the Dobbs case, we're up there the normal way. They do the writ of certiorari, and what the justices do when they get a writ of certiorari is they sit in a justice conference. This is a absolutely gorgeous room with 30-foot ceilings, beautiful wood paneling. They sit in that room and they debate the case. They've all read the briefs. Their law clerks have all read the briefs, and they make a decision. Should we accept this case for an appeal, for us to make a decision? If 4 of the 9 justices vote to accept a writ of certiorari, then it's accepted. So obviously 4 justices said they want to accept the Dobbs case. And by doing that, that means they're taking another look at the abortion issue. So they accepted the Dobbs case, and it was, as well, recently argued before the United States Supreme Court. Those oral arguments took place, and again, as you might imagine, the split was pretty much the same. You've got Justices Breyer, Sotomayor, and Kagan on one side, and the other 6 with the Chief Justice on the other side. But they had different views on how they would look at this. First off, Roe v. Wade is precedent. Precedent means it is a decision already made, and they should give great weight to decisions already made by prior courts. The reason the Fifth Circuit Court of Appeals declared the Mississippi statute unconstitutional would be because of precedent, which is what Roe v. Wade is. Because if they hadn't have done that, the Supreme Court would have slapped them down and said, hey, we've already passed on this. You can't make a decision that's in conflict with us because we're a higher court. But keep in mind, there is no higher court than the United States Supreme Court. So although there is precedent, although they have their own case law to take a look at to see whether or not historically they've ruled a certain way, they do not have to follow precedent. They can actually change it. And they have done this on several occasions. If you remember, at one point, slavery was legal, but that was changed later on. The Supreme Court said, no, we were wrong. It is illegal. And this happens over and over again. Separate but equal, segregation. All of these things were once precedent, but the Supreme Court reversed themselves and said, no, we were wrong, and this is the way it should be now. So they have the right to reverse themselves. Roe v. Wade is precedent, but the Supreme Court could reverse that. But they could reverse it in several ways. Viability, if you remember, I spoke about that just a little while ago. Viability was written into Roe v. Wade, another case called Casey. But viability was not a determining factor, was not the absolute rule. And the court could actually change that. So they could keep abortion legal, take out viability, and say the states have a right to pass legislation regulating abortion because abortion is legal. So they don't have to totally say abortion is illegal. They can also say, we want nothing to do with abortion, that this is strictly up to the states. That's another compromise position, is giving the states the right to make that decision. The 3 liberal justices want to keep Roe v. Wade exactly the way it is. The conservative justices, they went in several different ways. One saying that the Constitution does not say anything about abortion. And when the Constitution was written, it said nothing about abortion, and abortion was not considered. Therefore, you're writing into the Constitution a right to abortion. Another question asked by, I think it was Thomas, was, are there any other rights that are in the Constitution that resulted in somebody's death? I thought that was a key question, because what he's trying to do is show what really are rights in the Constitution, and should this be a constitutional right. So if it's not in the Constitution, some of the Supreme Court justices say, then we should not pass a statute, and we should not pass a law, and we should not make a decision creating a right that's not in the Constitution. The liberal justices, what they're saying is this is a right. A woman's body, protecting her body, we have rights to privacy. We do have these rights, and even though they're not specifically in there, they are created because of the concepts that are created within the Constitution. So you've got these 2 sides conflicting, and we'll have to see how it finally works out. And like I said, with the Roe case and that's Dobbs, the Dobbs case, there could be compromises, and there could be ways that it is determined that we can still have legalized abortion in this country, but it can be regulated by the states to a certain extent. The abortion clinic that brought the case in Dobbs is the only one still operating in the entire state of Mississippi. So all the other abortion clinics have closed up because of the regulation that Mississippi has placed upon abortion. So that's a key area when you're talking about the facts of the case. That's a key area. Can you regulate abortion in such a way that you eliminate abortion? That's something the Supreme Court's going to have to deal with. So now we have the situation where the oral arguments are done. What happens? In both of these cases, it will go back to a justice conference. Again, you go back to that room where just the justices are. No clerks are in there. No police are in there. Nobody's in there except for the 9 justices. And they discuss the case. Obviously, before they get there, they have read, like before, everything that was written. They have received briefings from their law clerks. And how important are law clerks? Let me give you an interesting statistic. Right now, we have 9 justices. Justice Breyer, Roberts, Kagan, Gorsuch, and Kavanaugh and Barrett. That's 1, 2, 3, 4, 5, 6 justices. They were once law clerks to Supreme Court justices. So an interesting fact, 6 of the 9 were the clerks that used to read the briefs, used to do the memos, and used to advise justices. And now they are Supreme Court justices. So they know how to rely on clerks, and they know how important clerks are. Clerks are usually the guys or girls who are number 1 or number 2 in their class at a particular Ivy League or prestigious college. Right now, the Supreme Court, you have 9 justices. Of the 9 justices, 4 are from Harvard, 4 are from Yale, and the newest, Justice Barrett, from Notre Dame. So it just goes to show you there's not as much diversity as you might think as to where all these people come from and what kind of educations they got and what kind of life experiences they've got. We've got Harvard, Yale, and 1 from Notre Dame. So they all go back into this room and they argue the case amongst themselves. And eventually, the Chief Justice, who is the person who kind of chairs the meeting, will take a vote. And if there is a majority, and if the Chief Justice is in the majority, he then assigns who will actually write the written opinion. The minority group, whoever the senior judge is in the minority group, the oldest judge, by service, gets to pick who will write the minority opinion. If the Chief Justice is not in the majority, then the senior justice in the majority picks who will write the opinion. The justices then go back to their offices. They sit down, and whoever is assigned to write the opinion will write the opinion and draft it. They then send it around to the other justices. The ones who voted the majority will look at the majority opinion. They may want to make some changes. Or maybe there's something they disagree with in the reasoning. And although they may vote in the majority, they may not agree with all the reasoning in that majority opinion. In that case, they can write what's called a concurring opinion, which means they'll put down their thoughts, but the bottom line is they agree with the majority and vote with the majority. The dissenting opinion does the same thing. The person assigned to write it will draft it and will send it around to everybody. Even after they vote and those are written, the justice can still change their vote. And that has happened. Justice Roberts changed his vote on Obamacare after the opinions were written. So it does happen. They're not locked into the vote they made in the Justice Conference. They can actually change their opinion. After it's written, after all the changes and amendments are done, a person in the majority could join the minority, a person in the minority could join the majority. Once the decision is made, once the final decision is written, they then convene the court again and they read the opinion. It's interesting to note that before the Dobbs case, the abortion case, came to the Supreme Court, and remember I told you they had to sit down and vote, and 4 justices had to vote for it? they had an unusual situation. They had 12 different times where they met in a justice conference to vote on that. Normally it's done once. They got together over 12 times to do this. And on the Dobbs case, there's a thing called amicus briefs, which are normally referred to as friends of the court, where other organizations who have an interest can write a brief. Sometimes, like for instance, in the Dobbs case, one of the amicus briefs were followed by the U.S. government. The U.S. government, under President Biden, the Attorney General, and the Solicitor General, it's an important concept, Solicitor General. Solicitor General is the office that represents the United States government in the Supreme Court. The Solicitor General actually asked to join on behalf of the abortion clinics to argue for that. And the Supreme Court gave the Solicitor General, as a courtesy, they normally always do, time to argue for the abortion clinic and on the side of the abortion clinic. But aside from that, so many organizations were involved that I counted, and I stopped counting after about 75 different organizations filed amicus briefs in support of one side or the other in that Dobbs abortion case. So there you have it. You have examples of two kinds of cases that had two kinds of tracks to the Supreme Court. How the Supreme Court decides those cases. Oh, one last thing. You know, I was talking about that OSHA case. They're not going to decide whether the government did or didn't have the right to pass those regulations. The emergency motion was whether or not to stay the regulations until they could be fully argued in the appellate courts, which means let's just stop these regulations until we can actually argue them, fully brief them, have the time to consider these regulations before they're enforced. So the Supreme Court was only deciding whether to temporarily stop enforcement of the OSHA regulations. So if you have any questions about how the Supreme Court operates or about these particular cases, just put them down there on the bottom and I'll be happy to try to answer them for you. Otherwise, have a nice day.
Thanks for watching this episode of The Lawyer You Know. If you like this content, please share it with your friends. Make sure you subscribe to our page and like our videos. If you want some interaction, get in the comments and we'll be sure to get back to you. If you want to know any more information about our firm or this page, you can find out in the description or visit tragoslaw.com. We post multiple times throughout the week, so make sure you hit that bell so you can get the notification and not miss out on the next episode.